Hi everyone, I'm Durga Prasad, Associate Professor, Department of ECE, and today I would like to make a presentation on a topic called Trade Secrets and False Advertising. This is one of the topics which have been related with our daily life, and it is one of the very important things because different companies, their success, their failure, and the competitors' advantage, everything depends on the trade secrets. So today let's have a look at what is trade secret and what are the different types of trade secrets, what are the issues related with the trade secrets, and how can we protect our trade secrets. Let me begin with. So, trade secret. What is this word? So we might have heard a term called trade secret in our daily life, secret in our life, but what exactly trade secret is? Secret is a term which is related with an information known to very few people. And that kind of information which is related to a business, it may be a technical information, it may be a financial information, it may be a commercial information, or it may be a negative information. So the trade secret can be related to any of these aspects of a business. Now for a business, the success depends on how well the trade secret is maintained. And for business, if it loses it, it will be definitely a competitive advantage to its competitors. So let's have a quick understanding of exactly what a trade secret is and how it has been implemented. Right. I told you that for a business, trade secret plays a very crucial role. And definitely when it is a trade secret or a secret, it has to be known to only limited people in the organization. But what exactly trade secret related with? Let's have a quick look on it. So you could find trade secret is related with aspects like a formula of a medicine, a formula of a soft drink, or you can talk about like a physical device, composition of device, or you take a bike or a car. The secret of mileage or the performance of the vehicle, that depends on the way that engine has been designed. All these kind of things related to a trade secret. For instance, we might have seen some movies where one company wins the bid over the other company. Now what's the trade secret there? There if one company quotes with one particular amount, the other company will be trying to deal with the same project with lower cost. So there the trade secret is related with financial information. Sometimes it relates with different ideas, the process of implementing the business, or the market strategy of it. Anything can be related with trade secret, and trade secret gives economic advantage for a company over its competitors. Now, what are the three important qualities which a trade secret must possess? The first and most important thing, people may understand that when any information remains as secret? When it is known only to very few people in the organization. And second thing, the person who knows the information should not reveal it to others. And next important thing is, what are the information we are talking about? It should have some commercial information. Something like with that information, they need to get maximum business. Without that, there is no importance for that information. So the second important thing is a trade secret should have a commercial value. Sir, I know this secret and I have shared with everyone, or I kept it as an open. Now when it is open, everyone will be able to read. So how do you say it as secret? When you want to say it as a secret, definitely you should have taken some measures so that that information is not shared with others. So that relates to the third quality of trade secret called reasonable steps taken to protect the trade secret information. So if your information is meeting all these three qualities, it should be secret, it should have commercial value, and there are reasonable steps taken to save it from others, you call it as a trade secret. Now let's have some of the well-known trade secrets in our industry. So as I told you, the trade secret may be related with composition, the formula, or the process of implementation. We have some famous trade secrets. I know when I talk about students, when I ask them what will we have your favorite food, at least some of you say that it's burger, or someone of you says that sir it's my KFC, or someone says what's your favorite drink, it may be a Coca-Cola. Now when I'm talking about a KFC or a Coca-Cola, the composition of those is also a trade secret. For instance, you talk about Coca-Cola today, still the actual composition is known only to very few people in the industry. So those kind of very important and confidential information, we can refer it as trade secrets. For some companies, before make their product as a patent, they would like to keep that information as a trade secret. Then you find some of the manufacturing techniques. Sir, everyone does the same product, but how do I get a trade secret, or how do I get benefit over others? The manufacturing techniques we adapt. Some people make the same product at 1000 and you make it at 2000, or you may make it at 200 rupees itself. So what is the secret behind that cost reduction? That is called trade secret. And sometimes the algorithms which we use, the programming which is involved, that should be a major reason for the success, and that can be a trade secret information. So what are the advantages you get when you have a trade secret protection? For instance, I talk about something like a trademark or a copyright or a patent. They have some time limits for 10 years, 20 years, 30 years. But when I talk about a product called or intellectual property called trade secret, it remains as a secret as long as it is revealed to others. If I am not revealing to anyone else, it remains as a trade secret. If I reveal it immediately, the next moment itself, it will not be a trade secret. So there is no particular time limit on this, and there is no process of application required. There is no registration required and no public disclosure. I need not say that this is my trade secret, because I know once I reveal it, people will start practicing the same techniques. So there is no mandatory that we disclose all this information, and because of these reasons, this particular intellectual property called trade secret is having more advantages compared with the remaining 3 intellectual properties. So these are the few examples which you could find, which are being the popular famous trade secrets. As I mentioned you, the formula of Coca-Cola is a trade secret, or you talk about KFC, it's a trade secret, or you talk about Burger King's or you talk about this WD formula. All these are different examples of trade secrets. Now let me tell you, their formulas or their composition is not revealed. Because of this, they got a competitive advantage over their competitors. So trade secrets should be very important intellectual property for an organization. And something like my industry is working on a new product. So before I launch that product into the market, before I put it a brand that this particular product is from my company, so that information, the product design or the composition or the ingredients or the components, everything should be kept as trade secret. So let me tell you, an important part, an innovation before it is converted as a patent should be protected as a trade secret. And if your product cannot get a patent status, it will remain as a trade secret until its life. Let me just put a quick difference between what exactly a trade secret and how it is different from patents. The first thing, as I told you, patent is related with innovations, but to get a patent, we need a registration with the particular organizations. But when you talk about trade secrets, no such registrations are required. So trade secrets doesn't require any registration, whereas your patents require registration. Sir, patents for different types got different time limits. For instance, you talk about a product, it got 20 years. You talk about some other related area, it may get 40 years. But for me, my trade secret can last as long as I keep that information as a trade secret information. And public disclosure, what do you mean by it? Public disclosure is something like where we have to express the things or the compositions with the public. And trade secret is never requires you or asks you to disclose your trade secret information. But patent, once you get it, you have to disclose it to the public so that the remaining people will not try to do the particular practice. So public disclosure is not required in case of trade secrets, but this is required in case of patents. So this is a major difference which you have between trade secrets and patents. So, sir, I would like to find out what happens when a particular trade secret has been revealed to someone else. Now, there are different practices in which actually the trade secret will be revealed to others. For instance, I want to share you my trade secret. I believe you that you are a reliable person and I want to share my trade secret. Before I reveal the trade secret, there is an important aspect called trade secret contractual agreement. What it means is, boss, I am trusting you. I want to share you with the important information. But I do this particularly with the respect that you will not reveal this information to my competitors. And in case if it is identified that you have shared this confidential information with my competitors, you are violating the contractual agreement which we have made. We call this particular concept as breach of contract. So when one of the two parties is trying to break the agreement which is made between both of them, that will be referred as breach of contract. This is one case in which you will find the trade secret information. The second case will be, you will find that some companies try to bribe the competitor company employees. They want to get some information. Hey boss, can you give this me information? I will pay you so much of amount. Or I will give you a job opportunity in my company. Or I will give you this properties. They try to extract information from the competitors' employees by bribing them. That is called as misappropriation. When you are trying to reveal your competitors' information using wrong practices, we call it as misappropriation. And if you are trying to get the information by involving one of the parties involved in the contract, we call it as breach of contract. So these are one of the two ways in which trade secret will be revealed to your competitors, right? So the trade secret can be revealed to the competitors either in the two ways. One is misappropriation, using wrong practices to reveal that information to the competitor, or one of the two parties who are involved in the contract is trying to break the contract and leak or share the information with your competitors. So when this misappropriation, that is in case if you claim that your competitor has got your trade secret information through some misappropriation practices, what are the various defenses that competitor make? Boss, I did not do any trade secret misappropriation. Why you are putting blame on us? So there is a chance that the competitor will put like this kind of claims on us. So what are the different things that a competitor can say when a particular company files a case that they have done the misappropriation? The first one they say is, boss, this product or this particular thing is our own creation. We don't depend on your project. It's their own independent creation. This is how one of the claims which your competitor can make. The next thing they say is, they say that no, we are not at all involved in any case and there is no wrong practices adapted in getting this information. Sometimes there is an interesting argument made by the competitors saying that, boss, you kept your information open. Everyone will get the information from your net or any other source. When you don't take protective measures, how do you claim that we have obtained your secret information? So they start claiming that companies have not taken actual measures to protect their information. The other ways can be latches, or you can find privileges through which the information has been revealed to the competitors. So these are the different defenses made by the competitor when you try to put a misappropriation claim on your competitors. So when it has been proved in the court of law, I put a case against a particular company that they have done the misappropriation. They have bribed my employee to get my information, or they have done some wrong practices. And fortunately, if we could prove that the competitor have done that wrong practices there. So what kind of things we can expect from the court of law is, first thing, the court will order that company that you have not got this information in a proper way, so you have to stop using that product or information. The second one is, this is one of the most important thing, companies will be fined with a large penalty, much more amount than what actually they have earned from it. For a very small instance, let me take in recent times, we saw a movie called Sam Roy, in which a publisher company would put a case against a movie director claiming that he has taken the reference of the script without their permission. In case if his claim has been proved that he has taken the information without the reference to publishers, he would have paid some lakhs to crores of rupees. Fortunate enough in that, he could claim that it was not misappropriated, so he was escaped from it. So these are some of the references which you can find where monetary damages can be expected. And sometimes a company may ask to seize the other company which have particularly used this misappropriation. For instance, a competitor got a formula and design from my company and started a company, and it is found that it was a misappropriation. So court will ask to seize that particular manufacturing plant because that was not done in a proper manner. Sometimes there may be something like, if some of the people are affected because of that misappropriation, they have been asked to pay some compensations. So these are the different remedies which have been given by the court of law whenever a misappropriation has been identified. Right. So as till now we have seen about what is a trade secret, what are the different types of trade secrets, then what are the measures expected, what are the qualities required for a trade secret, and what do you mean by misappropriation and breach of contract. So let me move ahead for the second topic of our discussion, which is very interesting, and we find this kind of things happening in our day-to-day life. The topic which I would like to present before you is called unfair competition. To talk about this, let me just start with a simple diagram or a picture representing number of people competing here, and one person has been standing ahead. It's unfair. People will say that, yes, sir, if a competition has to be fair, everyone should be given equal importance. But here one guy is given an additional information or additional importance. So that is what unfair competition is all about. So we have different ways in which the unfair competition actually is being implemented. Let me have a quick look on what are the different types of unfair competitions we have. So unfair competition is defined as something like doing wrong practices or wrong implementations to gain the market advantage. And what are the different types of unfair competition we have is, one is passing off, the second one is misappropriation, then right of publicity, then we have false advertising, then product disparagement, then dilution of product, and finally infringement of trade dress. So what are these different false unfair competition practices? Probably once we start discussing, you will be able to correlate with your everyday life. Yes sir, I have done it. So let me start in a discussion about all these different types of unfair competition practices. First, let me start with something called as infringement of trade dress. To understand this, let me make you people a very simple or relative example. Like, you people have a hobby of buying some good sports shoe. For instance, you go for a Nike showroom to try to get a good quality shoes. Your cost of shoe will be around 3,000. But you will find in a market like our Koti in Hyderabad, there a footpath seller will be selling that it is also kind of Nike shoe and selling that it is only cost of 800 rupees, and they will try to use a similar mark which is as same as Nike. Now this is called infringement of trade dress. The way a shoe of Nike shoe appears is called trade dress, and your local wala is trying to sell by keeping a similar trademark on that product is called infringement of trade dress. If people are good aware, they will understand this is not the original. But if people are not that intelligent, they deceive by purchasing this kind of products. This is first type of unfair competition which a company will do to sell their products. Now second one is called as dilution. What exactly dilution practices is kind of it. As I told you in the previous example, not only maintaining the design of the product, but trying to blur their trademarks. For instance, I talk like some simple example like a Nestle. For Nestle, we have two pigeons as the trademark. Now someone who is newly entering into the market wantedly try to use two different birds similar to a pigeon. But in case tomorrow if someone asks them, I did not use pigeons, I used parrots. So wantedly they try to confuse the customer by using a similar or a blurred mark of an existing trademark that is related with dilutions. And unauthorized use of mark for the poor quality products, we are referring it as tarnishment. As simple as here. Something like your quality of product is not good, but you want to sell to your customer, you want to deceive him by using some well-known trademark on your product. That is called dilution. And all of a sudden you will find this one will be interesting. For instance, your business does not have any relation with Hrithik Roshan or Vijay Devarkonda. All of a sudden you try to promote that this product is branded by him. Or you try to sell some land property saying that even Vijay Devarkonda will buy from our plots, or superstar Mahesh Babu is related with us. So actually if that particular celebrity is not related with your business, but if you're trying to misuse their brand image, they can put you a case under right of publicity. So when celebrities or the people who have a good image, and when you are trying to misuse their popularity for selling your products, you call it as right of publicity. And when the people doesn't want to get their reputation damaged, they can apply for this case under right of publicity. The next one is called passing off, right? Something like you are trying to sell some other company's products without their prior permission. So passing off is something happens when one party sells the goods and services by affixing the other company's trademarks on them. For instance, there is a new product by you and you want to make that product to be pushed fast. For instance, there is a company called Hindustan Unilever Limited, which is very famous for FMCG products. And your products is not at all related, or you don't have any association with it. But you are trying to use that good name of Hindustan Unilever and trying to sell your products. That is referred to as a passing off. So either you try to copy their trademarks, you try to copy their symbols, signs. For instance, you don't have any ISO certification, but you are trying to put a symbol like this, swastik mark, which is indication of quality. And you don't have any this swastik mark, or you are going to not get any ISO certification. But saying that it's my trademark, people are surprised, trademark of that company. So these kind of wrong practices which we adapt will be referred as passing off. So passing off is an offense which is done by misrepresenting the goods and services. And certainly that definitely will try to create a confusion in the mind of customers. So let me tell you in simple, unfair competition is all the wrong practices which the company does to try to sell the product to the customer. If it is fair and if it is true, it doesn't belong to unfair competition. And next one, which we have already learned in the other case, which is called misappropriation. And this happens when one party is trying to use the property of other without the information given to them. For instance, I want to use something like, I want to say that I am associated with one particular company, or I have my company has been a partner of that particular company, which is not true. For instance, we have big real estate companies like Aparna Constructions, and we try to say that our estate is also, our builders group is also a part of it, when we don't have any association with those kind of builders. Those kind of people can go ahead and say that these people are practicing misappropriation, and what we are trying to do is, Aparna Constructions is a well-known brand, and if we try to sell our flats or apartments under that brand, we know that definitely it will have a good brand image and we will get a high price. But in reality, we don't have any association with Aparna Constructions. So those kind of things will come under misappropriation practices, and in case if the company feels that it is creating a damage to their reputation, they can file a case against those practices. So this is one more unfair competition practice which companies adapt to sell their products to the customers. So let me discuss with one of the last practices of unfair competition, and this will be really interesting for our students. Then that practice is called as false advertising. Now we have a number of references in our daily life which will try to say that, for instance, you wake up in the morning and try to switch on any channel, there will be some different type of videos or advertisements saying that you will reduce your weight in 15 days or you become white in 1 month, or someone says that use our product, definitely you will be finding more shining yourself, more handsome, and someone says with this when you consume our powder or milk powder kind of things or energy drink, you will become so strong and you become muscular and all that. So how much is the reality in beyond? So when a company is trying to sell a product to the customer by using some false act of publishing or transmitting informations, that is what you call it as false advertising. We find sometimes a rare surprise advertisement saying that our banks or our company will give you 20% of rate of interest, which is really tough because our public sectors don't give more than 5% interest. Now, can we trust those kind of companies or not? So this kind of advertisements which are made by a company doing some wrong commitments to customers, we actually call it as false advertising practices. And the government have been trying to create a number of regulations to avoid people fall in this kind of wrong trap. You find some saying that we are from so and so company, you have won so and so lotteries and all that. So all these kind of things are also creating some wrong practices. And they say that 50% discount. And all of a sudden, once you make your shopping and everything, again in the bill you will find some additional cost. And this particular kind like terms and conditions apply, they don't mention in the earlier case. So they try to get a product at 0 rupees. Oh, free mein aa raha hai, we'll try to buy it. And all of a sudden what you find? At the end of the day, they say for 50%, you will get 50% extra. So these kind of things are come under a category called false advertising practices. And this need to be taken care by the consumer before making any purchase or decision about a product. So let me take you some examples in which this false advertising will be practiced. And first thing which I want to start, because I want to connect to students, let me take one of the best examples like Burger King. Today you have been watching your cricket, all of a sudden you find one of the ads from the burger saying that try our product, and you decided that you along with your friends go there. The ad, what the product shown was this, but finally when you order and get delivered, this will be like this. So you feel a bit disappointed. Or something like a Taco Bell's. You go there with this expectation and probably you will end with this kind of things. Or you find our celebrities or artists promoting this kind of fairness cream ads. Shah Rukh Khan was promoting it. Yami Gautam was promoting it, saying that in 6 weeks you become from this. But we know the reality. Okay. So people need to be wise in making a decision based on seeing the advertisement whether to buy a product or not. And all are the different practices which you could find in the real time where a company tries to deceive a customer so that the customer will be able to buy their product, and all these practices come under unfair competition. So here we try to cover various practices adapted by the company to implement unfair competition practices to sell their products. Thank you.